Good morning, afternoon, wherever you are. Howdy. How's everybody doing? Not legal advice, of course. Like, subscribe, share, comment, whatever you want to do. Nice to see all of you out there. Thanks for joining. Before I get into what we're going to talk about the order, the GTII order that came down yesterday. Before we get into that, this is obviously just opinion. Don't rely upon anything I say. Do your own research. Come to your own conclusions. Use what I say for entertainment purposes only, etc. Thanks again. Appreciate that. Quickly. So before we go into the GTII order, I wanted to reference a few things, of course. One, I keep on hearing, and some of these are jokes, some of these are just kind of my observations. I hear, and I don't know if where you are, they have this. It's a place called Children's Dental Fun Zone. So it's I guess, a dentist for kids. They have games and stuff like that. And I was thinking about it, how much fun I thought it was going to the dentist, which I do not. But I had a personal experience with it, which made it even more funny for me, is when I was a kid, my parents were broke. They were immigrants they were, originally Holocaust survivors. So when they came to the United States, they didn't have any money. And they lived in a connection or nearby a bunch of other Holocaust survivors in the LA area. And we went to this dentist, their dentist, who also, I think, was a Holocaust survivor, who believed in saving money for all these people who were new immigrants, etc. And so he didn't believe in using Novocaine. So that was my childhood experience with dentists. So when I hear Children Dental Fun Zone, it has an ironic meaning to myself. Okay. Now I'm going to give you two jokes. I don't care for these, but I'm going to throw them out anyway. I like a woman with a good head on her shoulders because I hate necks. And this is the second one, and I'm just not sure about this. I'm going to throw it out here, but I'm not really a big fan of this one either. My girlfriend is absolutely stunning, like a Greek statue, pale with no arms. I don't know about that one. Of course, I don't know about any of these. Life is like a box of chocolates. It doesn't last long if you're too fat. Okay. And last but not least, and this one I think you need to listen to very carefully. Apparently, smoking cannabis can affect short-term memory. Listen carefully. Apparently, short-term cannabis can affect short-term memory. All right. Before we go on to, I hope you understood that last joke. So before we go on to the order, one just brief thought that occurred to me. I remember hearing some lawyers say only lawyers could call a 50,000 word document a brief. Yeah. And sometimes, in fact, lawyers get paid by the word. So let's go on to the order. This is the kind of why you're all here, and thank you very much. So GTII, the order. So here's the order. Let's see what it looks like. You really can't see it. Oh, there it is. Sort of. Oh, there. Okay, there we go. So that's the order. And if you look at the top, it says electronically served by the court on 9/18/2024, which would have been yesterday at 10:53 a.m. So that's when it was entered and became effective. It has, a whole litany of plaintiffs, over 200, but then the lead plaintiff on this document is White Rocks. Then et al. Means there's a whole series, and if we look at the complaint, there's like 200 names. I'm on that list also, and I'm sure many of you are on those lists also. And the defendants in this, least listed in this action, are David Reichman, Kathy Griffin, Frank Benintendo, and Donald Gilbert, those 1 through X, etc. So that's who's listed, and global GTII is also listed as a nominal defendant, meaning that they are there because they're impacted, but they're not, the action is really not directed at them. So then the order goes into, and it's very similar to the order we had discussed briefly after the minute order in part, but it's a little bit more extensive. So I'm going to go through it. I'm try not to bore you to tears, and hopefully it will not. And if you have questions that I could see when I bend over like that, I will do it. If afterwards you have questions, feel free to put them in the stream. I don't want to go endlessly over this because it's not going to be helpful. To those kind of wondering what's going to happen from here, I might as well address that before I go into the order. So I've spoken to and communicated with the receiver who is on board. I expect to have further conversations with the receiver. I will tell you what I expect him to do as we go through the order. But just to let you know, that's ongoing, and I think a plan is being prepared as to what he's going to do. And of course, I will follow up and let you all know as soon as that is done. Because that's actually literally ongoing. So the way the order reads is it says everybody was there at the hearing, which was August 7th. It defines who the parties are. What's interesting here, and I find I like, is in the findings of fact, paragraph 2. So there's a bunch of findings of fact whereby the court has made factual decisions. And when it's referring to management, we talked about who, because there's claims about management. So who is management? And the way it's defined here, it's Reichman, Griffin, Benintendo, Gilbert, and Rabari. All of those are constituting management, which is really interesting. Then it talks about why GTII, again, this is findings of fact by the court, which means that if it went up on appeal, the appellate court would have to basically accept these facts as is and wouldn't make any determination about facts that are differently. So it's important that these determinations end up in our favor. So the court finds that we are likely to prevail on our claims that management has grossly mismanaged GTII, and we had a description of what management was, by failing to file its required disclosure statements with the OTC and SEC, causing GTII to become delinquent in its required disclosures, violating security laws and regulations. As such, management has put GTII in immediate, imminent danger of being delisted by the OTC and/or potential regulatory action by the SEC. Then and I'm jumping around because I'm not going to go over every single paragraph because it'll bore you guys to tears. It then talks about certain filings that were made in or about March of 2024 and March of 2023. And it says in April of 2023, management filed disclosures that contained recurring deficiencies relating to its reporting of insider transactions and beneficial ownership. This caused GTII to be downlisted by the OTC in 2023. That's finding of fact by the management. Finding of fact by the court against management. Then it talks about management failing to file their 10K disclosure, and that as a result of that, the stock was again downlisted. GTI is still delinquent and is required in its required filings and reporting. Further, the court found that plaintiffs are likely to prevail on their claims because management has grossly mismanaged GTII by filing materially false, misleading, and incomplete SEC disclosures, intentionally omitting material information from its disclosures. Management's false statements in GTII disclosures have put GTII in immediate, imminent danger of being delisted by the OTC and/or potential regulatory action by the SEC. So that's another finding of fact by the court of gross mismanagement by management of GTII. Then it says that in a 10-K that was filed, management verified the accuracy, but it contained materially false statements regarding officer and director compensation, beneficial ownership, related transactions, and director independence. So the court has found that there's inaccurate and materially false statements made with regard to that. And in fact, it says that management said that they hadn't been paid bonuses and that they have not received any stock option awards, and that there was no common stock beneficially owned by GTI directors and officers in 2022 and 2023. I didn't have to look at this, but we know like in January 25th of 2023, there's a whole bunch of stock that's issued, notwithstanding whatever else. It was later revealed that certain officers and directors had actually been erroneously paid at least 36 million plus shares of GTI stock, which at that time had a market price of more than $50 million. I mean, we're not talking about chump change. That is a significant amount of money, and we don't know how much it was sold. We don't know how much it was sold prior to that. But this is a finding by the court. Again, final finding of the court based upon the parties' submission of paperwork, all the pleadings, all the oral argument. And I'm just reading through it again. In the Form 10-K, so their submission to the SEC, management represented no executive officer, director, or any member of these individuals' immediate families or any corporation or organization with any of these individuals is an affiliate or has been indebted to us beginning the fiscal year. The evidence is to the contrary. There were a bunch of transactions with management, family members, friends, and affiliates and related parties where they personally benefited. Notably, these transactions included stock issuance to a nonprofit called the Hans and Rosie Epstein Memorial Committee, Inc., which is affiliated with Mr. Reichman. Again, a finding of fact by the court. Court has decided that's the conclusion as to that particular issue, and that's why they have appointed a receiver in part. Moreover, so we'll just continue on with the court's findings of fact. Moreover, the court finds the plaintiffs are likely to prevail in their claims because management grossly mismanaged GTII by personally enriching themselves at the expense of GTII and its stockholders, converting GTII assets, converting means taking, and issuing shares to benefit themselves, family members, friends, affiliates, and other related parties. Such conduct has jeopardized GTII's assets and put its business in imminent danger. Again, a finding of fact by the court. Be tough to overturn that conclusion. There would have to be a lot if we ever got to that point, and I don't know if we will ever get to that point, but if there was ever a trial, it would be a difficult showing to overcome, I think, in my opinion, because this is all opinion. In my opinion, it would be a tough burden to overcome. But that's pretty harsh findings with regard to converting, basically stealing. Conversion is misappropriating assets. They're taking assets that are not yours. It's a civil sense. It's not a criminal sense. But that is, you could say they're the same kind of conduct. And then benefiting themselves, family members, et cetera. And we don't know else beyond that because we haven't seen a full, audit that takes into account everything that has gone on. And I'm sure that's going to occur. It won't be through me, obviously, but I'm sure it's going to occur through the action in Nevada. And personally enriching themselves to the expense of GTI and its shareholders. I mean, isn't management supposed to protect shareholders and increase their value? And I think that was the mission statement. And I think in the communication I had with Jack Fattel, which would have been February of 2024, they said they recognized that they needed to do an acquisition to maximize something like this is not an exact quote, but basically an acquisition would work for the benefit of everybody and would maximize shareholder benefit. And here they're apparently working by the court's factual findings which resulted in the order appointing the receiver. They're finding to the opposite, that they are doing things to enrich themselves at the expense of shareholders. That's not what management is supposed to do. We don't hire management to do that. We don't mind, really, and I'm speaking for myself, I don't mind, if a management makes a ton of money. If everybody does too, then I don't care. I don't care if the CEO gets rich. I care less. But when the company has zero revenue, zero, then, that's pretty hard to justify. Even that, before I move on, even that 36 million shares, just think about it. So they paid themselves, and I like just to go back, and this is in the record, so this is common knowledge. They paid themselves 36 million shares based upon a deal in the future that didn't close, which is a completely improper basis for giving compensation anyway. You can't pay for future deal. But they paid themselves shares for that, and the point was, even if it had been done properly, the company had zero revenue. We're talking about, that was January of 2023. 2022 had zero revenue. 2023 had zero revenue. So even if they had done things properly, and even if all this stuff that I'm talking about didn't happen, why were these guys paying themselves apparently $50 million in January of 2023 when they didn't generate a dime? And, I guess the evidence, or people have told me, have referenced to me that they at least contacted them. And I think in the filings, there's numerous LOIs, letters of intent. So they met, and it appears they at least had meetings. So I'll give them that. And I don't know what happened because I never participated in any of them. But they met with a bunch of people, and they may have signed letters of intent. So a letter of intent is basically an agreement to agree. So we're both interested in doing a deal, and we will put this in writing, and there'll be conditions to it. And once all the conditions are completed, then you have a deal. But, usually until those conditions are met, then one side or the other might be able to get out, or there may be other escape hatches for it, and there may be money put up or not money put up. Anyway, there were numerous times of potential deals, and it was referenced. And if you look at their 10K, it's referenced throughout, but none of them closed. That's just odd. To me, that's odd. So if you end up in negotiations and you end up entering into, in good faith, an intention to go forward with a deal, but you never do you have are you making bad choices in who you're selecting because you entered into a letter of intent, or is there something else? I mean, I always wondered, they really wanted to have, if they ever, this is just my pure speculation, I wondered if they were concerned that there was stuff that had gone on, and this is pure speculation again, just my opinion and speculation, but I wondered why they had these opportunities to do all these deals and elected not to, and that made me think, is there something there that if there was an audit that was done, that would occurred connected to some acquisition or something like that, would an audit have shown things that management perhaps didn't want to come out? And is that the reason? And I don't know. I mean, that's the question more than anything else. But that's what it made me think, that the series of potential suitors that never were completed seemed odd. There were so many. I mean, I don't know. Again, I wasn't involved, but it just seemed odd in my view, without knowing anything further. So again, just to recap this, and this is paragraph 14 of the order, by the way, page 5 of 20. And again, it talks about the court finds that plaintiffs are likely to prevail in their claims that management has grossly mismanaged GTII by personally enriching themselves at the expense of GTII and its stockholders, converting GTII assets, and issuing shares to benefit themselves, family members, friends, affiliates, and other related parties. Such conduct has jeopardized GTI's assets and put its business in immediate, imminent danger. And that's just one section and one series of findings by the court, which engendered the order, which appointed the receiver. And again, tough to paint that with a rosy picture. I don't think, you can't For example, conversion is an intentional tort. So let's say you can have a car accident and you're not watching and you bang into another car and you're just negligent. That happens. Everybody, most people have been involved in some situation like that, or you bump into somebody at a supermarket with your shopping cart, you knock the cart ahead of you. So that's negligence. That happens. But conversion requires an intentional act. So you have to know that you're not entitled to those assets to convert them. So that's a serious charge. Besides the fact personally enriching themselves at the expense of GTII and stockholders, some lawyers might construe that or might claim. I don't know what it would determine because it's ultimately up to a judge to determine that, but some attorneys might claim that might constitute a finding of breach of fiduciary duty. I'm not saying that, but some people would say that. And then, of course, issuing shares to family, friends, and we have heard stuff about the foundations. That's really harsh stuff. Pretty tough to put a good spin on that. And counsel on the other side, if they are still involved in this case at that time, they have to, and most times, attorneys figure out some argument, and I'm sure they will. But this is really bad, in looking at it. And if you had to deal with this, and if I was representing GTII and these guys, and this is the order I had, it would be trouble. I would be concerned. I would be really concerned about the direction the case is going. And I would certainly communicate that to my client. So I would expect that happening also, because I had received some information that they knew and had conceded, or I had an expectation that the receivership order would be granted. So perhaps they're not still completely surprised, but their actions still surprise me. So let's keep on going on the order because it's so much fun. We often, part of this is we don't often get to be on the leveraged position. And now I think we as shareholders are in the leveraged position because management did not seem, based upon my own personal experience, did not seem to be too interested in my interests as a shareholder. And I know from my discussions with the now receiver that he's volunteered that. I didn't ask him about that, but he volunteered that was certainly a priority for him. So continuing on with this order, the form, referring to the Form 10K again, reveals that GTI has experienced significant operational deficits, reporting a net operating loss of approximately $13 million in 2022, a net loss of $83 million in 2023, and zero in revenue in both 2022 and 2023. So the judge really did get that. And again, I mean, it's just odd. And I know it's stock, so I don't know what it ends up being. But I remember, if I recall, the cash position changes too, and not in a favorable way, from 2022 to 2023. And why would there be even $13 million in losses in 2022? What was happening to justify that? And $83 million in 2023? Again, continuing on, while management reported no revenue, no ongoing operations, and completed no meaningful transactions in 2023, management was still paid over 30 million shares of GTI stock, which was valued at more than $50 million. And that's what we discussed. Notably, also, it says the 10K shows that the liabilities exceed the total assets. And the court's continuing. So the court is it's not completed. It's going on. Second, the court, we've had a series of factual findings of gross mismanagement and other things, and now the court's continuing. Second, the court finds that plaintiffs, GTII, and its other shareholders will suffer immediate, severe, and irreparable harm unless GTII and its management are enjoined from further issuances, transfers, and further fraudulent disclosures and omissions. As already set forth above, management has caused GTII to be delinquent in its disclosures, jeopardizing its listing, has filed false statements in GTI disclosures, putting GTII in immediate danger of being delisted, has engaged in self-dealing, conversion, and waste of GTI assets, putting GTII and its business in immediate and imminent danger. And it says that everybody who's a shareholder was going to suffer immediate and severe harm unless an injunction to prevent any further activities happens. So that's another issue, and it's again false statements, false disclosures, self-dealing, conversion, waste of GTI assets. Waste means just taking it for an improper purpose or using it for an improper purpose, and putting the business in danger, in imminent danger. And thirdly, the court finds the balance of hardships. So whenever you issue an injunction or a receivership, but more so an injunction, you have to balance the hardship to the plaintiff versus the defendant. You have to have some kind of balance. So if it's so harsh, you're not able to impose the remedy against the defendant. Third, the court finds that the balance of hardships favors plaintiffs. Again, as already set forth above, management has caused GTII to issue fraudulent financial disclosures, omit material information to the public and shareholders, and cause net operating losses exceeding $97 million over the last 2 years alone. Management's actions have endangered GTI's ability to continue to raise capital. Finally, the court finds that the receiver requested by plaintiffs, Paul L. Strickland, that's the gentleman who's the receiver, is competent and well situated to serve as equity receiver of GTII. The court notes that Mr. Strickland is ready and prepared to take immediate corrective action with respect to GTI's delinquent OTC and SEC filing. The court also notes Mr. Strickland's experience with managing OTC companies like GTII and has done so for several years. And that's the conclusion. Then it finds certain legal conclusions, and then it makes an order about what the receiver can and cannot do, and I'm just going to briefly go through it. So what the receiver can do is immediately the receiver can confiscate and is entitled to gain control over all the books and records of the company and all the assets. Immediately, the receiver is entitled and will take corrective action to make all the filings, complete the audits, will attempt to get the downlisting corrected, will then pursue the collection of any assets that can be returned if it's relevant, and they have a stake in that because their compensation is based in part on whether they can get assets back. So if they are able to secure assets, they get 10% of the gross amount of the assets that is recovered. So they have an interest in recovering the money for shareholders, because they also benefit personally. So they also can initiate litigation to the extent necessary to pursue the recovery of the assets. They can also terminate litigation to the extent necessary to preserve assets. They can also pursue deals and this is all, by the way, in the order. And even if it's not, it's like 10 pages. So I'm kind of summarizing. And it can make business decisions with regard to the company. It can hire and fire, theoretically get rid of the board. It could put in new board. So all those things. It could also initiate litigation and terminate litigation. That relates back to that cannabis joke, because I said that twice. And it could do everything that's required. Now, it's still an agent of the court. So it's not like the receiver acts independent of the court. The receiver acts as an agent of the court, and the receiver actually has to file reports to the court. And any significant decision has to be signed off by the court. And the receiver also is represented by counsel, so they get legal advice. So there's a whole system set up. So what will happen, since the receiver has already been appointed, I've been in communication, I will have, I'm sure, in the next, either the end of this week, but I'll probably be next week, I'm sure I will have further discussions with the receiver or the receiver's counsel, but my discussions to date have been directly with the receiver. I'm sure I will get a general plan and feeling of what they intend to do, and I will report back. I don't know the time frame, but I think the receiver is ready to go. So I think they're rolling as is. To the extent that any audit work has been completed, I don't know if any of you recall, but Borgers was the auditor for this company. By the way, and just I'll throw it in before we go to Borgers, Alpine I checked again, that appeal still hasn't come in, so Alpine is still open. Just for the record, so everybody, because that's obviously an interesting issue. So Borgers did the 2022 and 2023 financials for GTII. Borgers ended up being a scam outfit, which is unusual that it was selected by GTI to do theirs, in that the CEO, CFO, chief accounting officer, who was a tax expert, apparently chose them. But they did the returns. They were banished by the SEC in May of 2024. So for everybody, for all their clients, it was like they might have looked at like 1,500 audits during a 2 or 3 year period. And apparently Borgers just was making up documents, copying documents. And I will bring up something that's of interest. I'm not going to bring it up today because I want to let a little time pass for a reason, which I'll talk about when the time comes. But even in this particular matter, if you reviewed their work, you could see problems with their work product. That's all I can say. But as a result, and because they were chosen and stayed, an audit of the financials 2022 and 2023 had to be done. Apparently, a company was hired. Fortune CPA was hired. Apparently, they're doing the work. They haven't contacted me, so I wonder about that. But apparently, they're doing the work. When the receiver, since the receiver is in, it's not like the receiver is going to be in. The receiver now technically is running the day-to-day operations of the business. But the receiver has his own forensic accountant who, if needed, can do the accounting. And also, I'm sure we'll go back and analyze the transactional history of the company, because perhaps, and I don't know if this is true, but is there a correlation between, and I don't know because I haven't looked, but is there some correlation that, like, on a day where there's a PR that says we're going to do a deal with X, Y, and Z, is there a stock sale on that day too? I mean, so is there like they enter into these purported agreements, and then I don't know, is there a because I don't know, because I haven't looked at it. Just somebody threw it out to me, and I thought it was an interesting topic. Does the stock sales by management correlate to PRs related to LOIs? Did that happen? And I don't know, but it would be interesting if somebody wanted to correlate it to see if it's true or not true, because maybe it's helpful for the other side. I don't know, but it's pretty interesting. I thought as a concept. So he has his own accounting firm. He has a law firm. So if there needs to be forensic accounting, that will be done. So let's kind of go through it again. All corrective action. That means the returns will attempt to get us so we're out of the expert market. All filings, hopefully, and I haven't specifically discussed it with him, but I will. The prior downlisting in April of 2023 that got us to pink sheets, that I'm going to talk to him about that also, about whether that can be rectified too. So perhaps we could kill both down listings, because it appears that the reason we got sent to the expert market is because of that prior down listing, which made us skip one step. Otherwise, perhaps we would have just been pink sheet and we would have all been tradable. Obviously, until it's tradable for everything, we all can't do very much. But I notice again, there's very little trading, and now it's probably a confusing for everybody out there. It's probably a confusing stock because they don't know what's going to happen. They don't know what action specifically the receiver is going to take. They may believe that the receiver might benefit the shareholders much more than what's been going on, certainly over the last year and a half. I don't know prior to that, but certainly over the last year and a half. But we'll have to see. So the receiver is going to do the corrective action, filings, audits, hopefully get us back to trading status, pursue whatever litigation is necessary, stop whatever litigation is not necessary, stop expenditures, seek the return of assets, stock, securities that can be returned, and pursue other relief that's appropriate. They will also, and I know this for a fact, they will also accept and welcome any business opportunities. So to the extent, and I know they've been approached already, but to the extent there's anyone who wants to do business with GTII, wants to do an acquisition, wants to do whatever, I know the receiver is open to that. So, when we talked about it, keep getting everything clean, getting it back to trading, getting acquisitions, getting income into the company, and seeing where the company goes. That seems like the most prudent way to go. Because again, I know a lot of people are interested in short squeezes, etc., but there's no way, I don't believe. Do I know? Of course I don't know, but I don't believe there's a way of knowing exactly when and if something will occur. But I do know that if a company becomes profitable, then that generally has a positive effect on the stock. And remember this, and again, so I've kind of outlined the order for you again, that just as a coup de grace, I've brought this up many times. If you look at their website, even after, it kind of shocks me. So, you tell somebody something and they don't correct it. And why don't they correct it? And, like I've told you, is that website says, for example, I think it says that they were SEC compliant. Kind of why would you want to come to us on the investor relations website? Why would you want to come to us? And part of the reason you would bring your company to us is because we're, basically an incubator, but we're SEC compliant. We can provide you the base for getting your company public. But they're not SEC compliant. So it's really shocking to me that they still maintain that. And I guess I probably should communicate. It's interesting. I haven't thought about that, but I should need to communicate that to the receiver also to change the character of the website to reflect really what's going on. Anyway, if I'm going to take a quick look to my right, which is the left. I didn't see the Trento email. Oh, what's next, GTI? There is, I don't know if it was Trento or, because Trento was a specific project. And again, something I wasn't involved with. So I don't know. I know that they were approached, and I know that there was Trento was, I think, a mine. Again, I don't know specifically. So I'm just kind of guessing here, but Trento, I think, was a deal in Chile, and I think there was related deals related to other mines in Chile, but I never went to the mines. I didn't meet any of the money people. I didn't do any due diligence, so I don't know anything about those deals. I don't know what deal will come to GTII, if any deal. I just know that there were plenty of people that seemed to have reached out at some point in time that were interested. Again, part of the interest was because they believed there was a concentrated short position, and they thought if they get if they got shares and there was a squeeze, they could do well also. But I don't know. But I do know that there are people who are interested, and I expect other companies will be interested probably for the same reason. They know that at some point in time, even if we don't know today what it is, but we know there was a concentrated short position referenced in a filing. We don't know what happened after that filing, so perhaps there's not a concentrated short position anymore. But there's a lot of people that still believe it. So perhaps there is. And even if there isn't, if there's enough people to believe it, maybe that has that effect too. This is certainly not financial advice, by the way, amongst not being legal advice, of course, also. But the receiver indicated that his interest, of course, is in enhancing shareholder value. So I expect that to happen. And and his job will be to try to correct all the deficiencies that existed after our current management had their opportunity to do whatever they thought was helpful. Doesn't seem like they did a great job of doing that, but certainly over the past year and a half. I don't know prior to 23. And again, I propose, I've had a lot of involvement in litigation, in particular with small companies. And a lot of times the principles and a company, if it's incorporated or it's an LLC, whatever, you have to comply with whatever the rules are. So to get the protection of an entity, and what that means is you use the entity so you don't have any personal liability. So anything that goes, any problem that arises gets stuck with the entity and the person is safe. But you have to comply with certain formalities and certain things you have to do. And you can't operate and use the entity as your own personal piggy bank or as your own. You can't control it, can't undercapitalize it. You have to follow formalities, etc. And after a while, you kind of get used to it. So, if you have a company and it's going on for many, many, many years, you get used to that. And your expectation is probably nobody's ever going to challenge it. And you can go basically do your thing and forever. And I think that's possibly what happened here. And at some point in time, unfortunately, it got to the point that it seems like, in my opinion, it seems like management did a bunch of stuff that, they probably shouldn't have, according to this order. And they probably didn't think they were going to be called on it because nobody was really pursuing them. And it's a small company, and they might have had the internal belief that in essence it was their company, their personal company, and their personal piggy bank, and they could operate it as such. That happens. I mean, I've seen it happen many times. People just disregard the rules and they hope for the best. And listen, most times, this happens to be a unique circumstance. Somebody paid for this particular lawsuit we're involved in that got us to this point of having a receiver appointed. It was because it had a bunch of interested shareholders, one, and committed shareholders. And that's been noted, by the way, even in the people who said they were interested in acquiring. Part of that point is they liked the shareholder base. They thought it was a dedicated share base. So you need the shareholders, but you also need somebody to fund the litigation. And luckily enough, we have somebody to fund the litigation. But without that, it's tough to get to the end point. We would never, or it would have been much more difficult to get this order without having both the shareholder commitment and the financial commitment. Now, one thing, and I don't know, if any of you out there are invested in any other companies that are based in Nevada. But based on now this order, you could certainly, if you had a company that you thought management was not acting properly, because again, I've seen the ride. So I started with MMTLP. I've seen the regulators kind of goof around, the hedge funds, the brokers, etc. This is management. So I guess it could apply to brokers too, although, obviously there are arbitration issues with brokers. But if any of you are all involved in companies that are incorporated in Nevada or do business in Nevada, and you think management's screwing around with you, you don't have to be theoretically a 10% owner of the company to be able to pursue action. Recall in this action, the initial statute was 10% ownership of the shares, which ended up being, I don't know, 38 million shares or something like that, because there was a Nevada statute that said you can seek a receiver, and I'm not quoting it exactly, of course, but you can seek a receiver without, for breach of fiduciary duty, if you have 10% of the shares that are outstanding, which is quite a high total. We were able to do it, putting together a bunch of people, but there were 3 other bases by which the court could appoint a receiver and kind of take over a company for the benefit of the shareholders. One of those says basically, in other cases in Nevada in which receivers have been appointed. So now this case where the court has found gross mismanagement is that type of case. So if you have another case where there's been gross mismanagement, you could literally attach this order. And again, I'm not a Nevada lawyer. This is not legal advice. Go seek same. But I would think if I were pursuing it, I would think I would use this order to say this is the type of order where it shows that this is the situation is perfectly acceptable for appointment of a receiver, which would broaden the pressure on management. Because again, it's not just the brokers, hedge funds, capital markets, etc. Sometimes it's bad management too. And sometimes they could be both present. They can both be in existence. They could both be, could be a great company, it could be a short squeeze, could be not short squeeze, could be bad management, could be a reason for, a lot of shorts also. So anyway, for those of you who might be in Nevada and who might be involved in other stocks where you think this is going on, you might be able to pursue something. Now, could you pursue it on a grand scheme, getting together hundreds of plaintiffs? Maybe you don't have to. Maybe you could do it on your own. Because again, if you're a shareholder, an individual shareholder, you don't have to have 10%. The court might not look at you or might not give you as much discretion, might not consider your concerns as much, but technically you can. And it's interesting to state that when there was the argument in court, the other side didn't argue when the discussion was that 10% of the total shares. They said, this being defendants, Gtii and the board's counsel, they said 90% of the shareholders aren't objecting or are against. No, they didn't say aren't objecting, are against the relief sought. Now, of course, they're not against it, but it was interesting they said that. So 10% was important to them, and they spent most of their time on the 10%. But now I would focus my time on other, doesn't have to be 10%. So that's, I think, a remedy that might be available to other companies, because there's a lot of companies that are incorporated in Nevada. And if it's a situation, again, where you think, and you can prove, of course you have to prove it, that there's a breach of fiduciary duty that's really harming shareholders, I really do believe this might be another avenue for doing that. And if anybody at some point in time needs a referral to counsel in Nevada who handled this matter, I'm happy to provide that. Obviously, you could choose who you want, but just so you have at least one reference point if you so desire. No pressure, no obligation. You don't have to ask. So that's it. I said I was going to do a brief one, and I lied. I didn't do a brief as I said. I'm going to take a quick look to my left. If there's any questions, if anybody wants to put it in the comments, I'll take a quick look before I go. But other than that, I will bring you up to speed when I speak to and I have a better grasp of the plan of the receiver. Anything else that happens in the meantime, I will let you know. I have put a demand in them to drop my action, demand into current management to drop my action. It'll be interesting to see what happens to the action now that we have a receiver in place. And it'll be interesting to see how fast everybody's going to still have to be patient. I know everybody thinks that I think this is a big obviously it's a big victory for a lot of reasons. One, because it's hard to do. Two, because it doesn't happen a lot. Three, because retail often isn't able to get victories. So I appreciate that for everybody. And I'm really happy for everybody. So that part's good, even though we don't know where it's going to go. But it could take still a considerable amount of time to correct all the deficiencies, so we still have to be patient. But I believe that if we're able to correct all the deficiencies and do everything that I think the receiver will be empowered to do, if we're able to complete that, I think at the end we'll be in a much better position. That's all I can say. I don't know if that translates to a higher stock price, because that I don't know, and there's no way of knowing. But I think the company will be in a much better position, hopefully, to operate in the future and to be beneficial to all of us. So to all you out there, I appreciate you all. Thank you for coming on board. If you haven't subscribed, please do so, and please share it, like, whatever. And if you have questions after this, something I said that didn't make any sense or was confusing, please reach out, put it in the comments, and I'll try to clarify it if I can. Sometimes I can't clarify it. I'm looking to see if there's any further questions. Will the receiver connect? I'll just answer that question. Will the receiver connect with Rabari? I presume that's already happened. I presume that probably yesterday. The order was issued yesterday. I presume that the receiver probably sent out letters, emails to management saying I'm appointed, and probably made a request for the books and records, etc. So I think that's already done. Yeah, and I'm sure Mr. Rabari knew it was coming anyway. My guess. Even like when I did a video with JR, we did it on what day was it? Tuesday, I think we did it. Yeah, because he wasn't available because of Monday Night Football. I said I would tell you Wednesday what the date was for the order. As of Tuesday, I knew it already, but I didn't want to disclose it because I didn't want to give the opportunity for the other side to take any kind of preemptive action before the order came out. And the order came out officially the next day. I didn't know for sure it was coming out. That was my strong guess. That's what I would say, that it was coming out that day. So anyway, I wanted to thank everybody again. Again, if you have questions, feel free. And again, I'm taking one more look to again, it looks to the left on the screen. It looks to the left, but I'm actually going to the right. Nothing else I see. So everybody have a great day. Be well. Take care. I'll try to keep you apprised as we've done. And if you have questions when this is posted, just put the question in the comments. Take care, everybody. Have a great day. Be well. And thanks for your support.